Good afternoon. My name is Cecilia Tortajada. I am professor in practice at the School of Social and Environmental Sustainability, University of Glasgow. I will moderate the webinar on impacts of armed conflicts on water today. Impacts of armed conflicts on water resources can be significant. They can include direct and indirect pollution of water sources, destruction of infrastructure, disruption of water access for civilians, leakage of salts, toxic material, and heavy metals into fresh water with long-lasting and yet unknown consequences to human health and the environment. Concerns also include potential weaponization of water by deliberately rendering it scarce and or insecure, leading this to health risk and environmental damage, particularly in areas with existing water scarcity problems. This webinar will discuss the nature of the impacts of armed conflicts on water resources, the roles of international humanitarian law and human rights law, and how does international humanitarian law protect water, in addition, of course, to accountability aspects. Our distinguished panel members are Dr. Carl Bruch, Director of International Programs at the Environmental Law Institute and Executive Director of the Environmental Peacebuilding Association. Dr. Professor Marcos E. Orellana, United Nations Special Rapporteur on Toxics and Human Rights. In this role, he reports to the UN Human Rights Council and the UN General Assembly. He is also professor at the American University Washington College of Law, where he teaches international law and environmental law courses. Last but not least, Dr. Mara Tignino, Senior Lecturer at the Faculty of Law and the Global Studies Institute at the University of Geneva, and Senior International Law Specialist of the Platform for International Water Law at the Geneva Water Hub. Thank you to all of you for participating on this webinar. Our event today is meant to be a conversation which I will facilitate with some questions. Our online audience will have the opportunity to ask also questions at any point during the event, and our panel members will answer them towards the end of it. We will close with short reflections on views towards the future. So let me start this conversation by asking, what is the situation at present in the world? Carl, could you give us your views, please, followed by Marcos and Mara?
Sure, thank you, and it's an honor to be here with you all. At a very high level, I think it's fairly safe to say that we have a lot of legal protections. There may be some gaps in some ways they could be strengthened, but we have a good number of legal protections. We have institutions with mandates to work on these issues. We have some practice in terms of preventing damage to water resources during armed conflict, for example, in military manuals. And then we have some limited application to accountability, but in many respects, accountability for wartime environmental damage lags behind other aspects of environmental damage during wartime. And I will say that in practice, we see a lot of these legal protections being honored in the breach, targeting of water infrastructure in Yemen, Sudan, Ukraine, and elsewhere, targeting of dams in Ukraine, Iraq, the Balkans. So there's a lot of people often think there isn't much in place. There is. The problem is we're not effectively implementing or enforcing it.
Thank you. Marcos, would you like to add some more comments to what Carl already said?
Thank you, Cecilia. And first of all, thank you for the kind invitation to join this conversation. A couple of observations on the situation at present. Echoing what Carl has just mentioned, we have seen the emergence of standards that are applicable in this area. And I wish to highlight in the human rights context, standards in connection with the recognition of water as a fundamental human right. This has come about by action by both the UN Human Rights Council and the UN General Assembly back in 2010. the recognition of the right to water as a standalone right has enabled a focused conversation about normative content, which is separate from the right to an adequate standard of living, and which has allowed for a more granular understanding of what access to water means, availability, affordability, which have been perhaps largely the focus of discussions in this area, but also, and this is, I think, the point I wish to highlight, the elements of pollution and safety and cleanliness, and all of that has been buttressed, as it were, by the recognition at the global level, again by the Human Rights Council and the UN General Assembly, of the right to a clean, healthy, and sustainable environment. There's much that can be said about how this right to a healthy environment is being implemented, trickling down to the regional levels and certainly to the national level. And I think this is a big element of what the situation is at present, the emergence of these standards. Secondly, I would also mention there are lingering questions on the interaction between international humanitarian law and human rights. I'll pose that because I think we'll come back to that. And then the third element, this is my final one, is the situation at present is that we're seeing in reality adverse impacts on water access or water quality in conflicts or situations involving armed conflict or occupation around the world, whether it is in Ukraine or in the occupied Palestinian territories or in internal armed conflicts such as in Colombia and elsewhere. We're seeing that water resources are often either the target or an element in the interactions between disputing parties in an armed conflict. I'll leave it at that for these initial observations. Thank you.
Thank you. Mara, could you please also give us your views?
Yes, thank you. Many thanks for the invitation to the University of Glasgow. So no, I completely agree about what it was said previously. Maybe no, what I would like to highlight it is that we don't only have like the traditional legal frameworks applicable to armed conflict given from international humanitarian law, human rights law, but we have also in the last years having seen really the development of new instruments that in a way complement the traditional sources of international law. And here, for example, I refer to the principles of the International Law Commission on the Protection of the Environment in relation to armed conflict, but also the ICRC guidelines on the protection of the natural environment, the Declaration on the Reduction of Explosive Weapons. So we see really that beyond the traditional sources of international law, like treaties, we have also other kinds of instruments that try really to follow up the practice and filling the gaps in a sense of the traditional sources of international law. And then we have also, I would like to say from the Geneva Water Hub perspective that we have also initiative like the Alliance to Spare Water from Armed Conflict, that it is an initiative of Switzerland and Slovenia that try really to galvanize the efforts to protect the water in armed conflict. So this is also an example that where we do not have that we do not have only the traditional norms of international humanitarian law and human rights law, but we have also states that are engaging in new initiatives to make really effective the protection of water during armed conflict. Thank you.
Let me come back, before we go to another topic, let me come back to one of the comments you made. These new instruments you have mentioned, they are the result of what? That we see more is needed, that we see in the world more states that require that those instruments that can be more applicable, or what do they respond to? And how effective are they?
Yeah, I think that in particular, no, the need to protect better the environment. This is really no a concern of the last decade, and also no we see the nature of the armed conflict that has changed. So no, unfortunately, conflict no they last over a number of years, over decades. And also now we have a different nature of armed conflict that it takes increasingly place in cities. And so from the point of view also not only of the environment but also of the infrastructure, when armed conflict takes place in cities, we have the interconnection of infrastructure. So I need to better protect this for ensuring the survival of people.
Carl, would you like to add anything to what Mara has just mentioned?
I think that Mara's spot on. I think that there's a challenge in how international humanitarian law views the environment in terms of protecting water, but the water infrastructure is not considered the environment. It can still be civilian objects that are protected, but I think that there's this tension that I think human rights law does a good job of kind of complementing and helping to understand how we think about these things.
Thank you, Marcos.
Thank you. A couple thoughts that I would bring into the conversation in connection with your question and the points that have been raised by Mara and Carl are that under the framework of sustainable development, there is a strong emphasis on integration of various bodies of law, various bodies of practice. Now, this focus of integration is certainly not new to international law that has for many decades tried to polish the tools for the dialogue between different international legal regimes. And so the dialogue between international humanitarian law and human rights law, for example. But under the framework of sustainable development, this gains a new light because this integration is a key component of the efforts at dealing with issues not in an isolated manner, but in an integrated manner. Some of the lessons from the integration between human rights and the environment, I think, are relevant here, and they are relevant also to the way that international humanitarian law may be interpreted. And so, for example, the content of internationally protected rights, and not only the right to water, but the right to life, the right to health, the right to a healthy environment, in connection, say, with standards developed under the World Health Organization, in connection with quantity as well as quality, and so pollution or the presence of hazardous substances. These standards find a way, as it were, through a transmission belt from the environment, the granular shaping of those standards into the more general dimensions of human rights obligations. I think that interaction under the framework of sustainable development opens many opportunities for normative dialogue, for integration, and so for coherence and for regime building.
Thank you for yes, Carl, please.
I just wanted to follow on that. I think that I completely agree that there's more movement toward integration. I am not certain it's because of sustainable development. I say this because when I first started working on this topic almost 30 years ago, a lot of people viewed international humanitarian law as lex specialis, and all the environment stuff was over there, and the development stuff was over there, and human rights were over there. And when you're talking about what governs conduct during armed conflict, it was only international humanitarian law. And I think that there has been integration. I think that but part of that integration has been kind of at the public international law level. There's been this integration within sustainable development of environment, social, and economics. There's this broader integration that we've seen, so that the International Court of Justice has said on a number of occasions that international human rights law continues to apply during armed conflict. And it's integrating there. And you have the International Law Commission in its draft text on the impact of the effects of armed conflicts on treaties, says that peacetime law, whether it's environmental law or human rights law or whatever, continues to apply during armed conflict, unless there's a direct conflict, in which international humanitarian law is still lex specialis. And so I think that the other thing is kind of on the fragmentation of international law. The International Law Commission also said we need to view this as a comprehensive system, not just kind of lex specialis and partitioning, but that we need to look at how these things integrate. And only when there's a direct conflict do you invoke the principle of lex specialis. And so I think that we're seeing integration across, kind of within the sphere of sustainable development, but even more broadly.
So now let's go precisely to the international humanitarian law and the human rights law. What is the interaction in respect to water? No, to any of you. So interaction between international humanitarian law and human rights law in respect to water.
Maybe I can start. I think that from the general comment number 15 of the UN Committee on Economic, Social and Cultural Rights, it was 2002. It was clear that there was really a close connection between international humanitarian law and human rights law. So now, if you look at this document of 2002, you can see that the UN Committee on Economic, Social and Cultural Rights refers to the provision of international humanitarian law as a basis also of the human right to water. So I think as Carl was saying, when there is a conflict, there can be a derogation. But I think, at least also in my research, that really when we look at the specific case of water, there is no conflict between the norms. So they really complement each other. So how they complement? For me, an important aspect when we look at the human rights law, it is the access to the judicial or quasi-judicial avenues for individuals. So when you apply human rights law, individuals can also bring claims about the violation of international human rights law, in particular, their right to water. So I think that in this relation, there is really a complementarity between international humanitarian law and human rights law, because the right to water can be brought by individuals and communities to human rights courts. Thank you.
Marcos, would you have any comment on that?
Thank you. Well, I wish to echo, first of all, Dr. Tignino's point about complementarity. And I think we're seeing this reflected as well in certain pronouncements, high-profile pronouncements that have come up in the field. And I'm referring, for example, to the 2023 advisory opinion by the International Court of Justice on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territories. In that advisory opinion, I wish to highlight 2 points. One is on the exploitation of natural resources. In the court's treatment and analysis of this issue, the point about complementarity comes across very strongly. So when the court speaks to how the use must be sustainable and avoid environmental harm, and these are the words of the court. The court then refers to the UN Declaration on the Environment and Development, so-called the Rio Declaration from 1992. So this sets the parameters, it articulates the principles of sustainable development. It refers to the UN Committee on Economic, Social, Cultural Rights that Mara just mentioned. It refers to reports by the Office of the High Commissioner for Human Rights that in turn refer to standards by the World Health Organization. And it also refers to the International Law Commission principles on protection of environment in relation to armed conflict. So all of this goes to say that under the frame of sustainability and avoiding environmental harm, these various tools at integration and so to achieve complementarity. So that's a first point. And the second point is that human rights has a central element and role to play in that analysis. And we see this in the courts, in the International Court of Justice's advisory opinion as well, in its treatment of what it considers a principle and the right of peoples to permanent sovereignty over natural resources. Two things here. One is that in the court's treatment, this right to permanent sovereignty over natural resources is linked directly to the right of self-determination. It is treated as an element of self-determination. Let's recall on that self-determination is a fundamental right included in the Bill of Rights, so the International Covenant on Civil and Political Rights, International Covenant on Economic, Social, Cultural Rights. And in those instruments, Article 1 of them, they express that in no case may a people be deprived of its own means of subsistence. And so water comes in directly in this regard, in connection with self-determination, in connection with permanent sovereignty over natural resources. And so the relevance of human rights in complementing international humanitarian standards is ostensible.
Thank you, Marcos. Carl, you mentioned you have been working on this topic for over 30 years. So during the years you have been working on this, how have you seen evolving the laws, their complementarity? Towards the end, we will go to where do we go from here, but is there a trend? Do we need another law, or these laws, they compaginate each other quite well?
I think that international humanitarian law often is the most, I don't know if I want to say the most rigid, but it's particularly rigid and often very narrow in certain ways. And other bodies of law, like human rights law, also international environmental law, international criminal law, help to fill some of the gaps through complementarity. And we see this both in terms of the question of whether a conflict is international armed conflict, in which there tend to be more protections under international humanitarian law, whether it's non-international armed conflict, in which countries have said, we want to have more discretion in how to deal with criminals as they see them internally, separatists, whatever. And so the protections under international humanitarian law for NIACs, for non-international armed conflicts, are much more modest. And in this case, bodies of international law like human rights law that apply equally to everyone, I think are very important. I also think that there's sometimes a question about when international humanitarian law applies. It applies generally during armed conflict. Now, if you have an extended period of unrest, sometimes conflict, sometimes occupation, what law applies? You know, when the U.S. was in Afghanistan, at what point did international humanitarian law apply? At what point did it not apply? Well, human rights law applied at all times. And I think that this complementarity is really important. I think it's also been recognized in many of the instruments that Dr. Tignino mentioned earlier, including the International Law Commission's principles on protection of the environment in relation to armed conflict, drawing upon these different bodies of law.
Now, following with thank you for this. Following with Carl's comments, if three of you can comment, please, on how does international humanitarian law protect water?
Yeah, maybe I start with some general remarks. I think that no, what it is really interesting, in a sense, also fascinating. It is that water takes different forms. No, so it can be a water well, it can be a water pipe, it can be a treatment plant, it can be a dam, it can be a river. So many different forms of water, and in this sense, no, there are also different norms that apply to the object that you are considering. So no, I would like not to mention that it is important to start from the general principles of international humanitarian law. So no, maybe the first thing that on which international humanitarian law is based, it is trying not to do this balance between military necessity and humanitarian consideration. So in each norm, you can see in a way this balance. And then in particular for protecting civilians and civilian objects, so you have the main principle, the cardinal principle of international humanitarian law, as it was said by the International Court of Justice, the distinction principle, so between military objective and civilian object. You have the principle of proportionality, so even when you are attacking a military objective, you must take into account the negative consequences that you can cause on the civilian object and civilians. You have the principle of precautions, so when are you attacking the military objective, or you need not to situate the civilians or civilian objects near military objectives. So you have these big general principles, and then the importance of water has been underlined with specific provisions on water in the additional protocols of 1977 to the Geneva Convention. And so there are like three frames on the protection of water. So water as a basic need, so as an essential mean for the survival of the civilian population. And here it is important the protection that the additional protocol also gives, because they talk about prohibition of attacking, destroying, removing, or rendering useless. So it's really a rigid legal framework that comes from the prohibition of starvation, because it is this the deprivation of water. It is like the deprivation of the liquids, of the liquid food, we can say. And then you have the prohibition of attacking installation containing dangerous forces, so namely dams and dikes, and the dangerous forces is water. And here you have a prohibition of attacking these objects, even if they are military objectives. So here it is a double standard of protection. And then you have the provisions on the protection of water as a river, as an aquifer, that are the prohibition against long-term severe and widespread damage that are completed by the instruments that I just mentioned, that we just mentioned before. So I think that really the frame that gives international humanitarian law is a strong legal framework. We don't have only treaties, so we don't have only additional protocols and conventions, also No, also we have specific norms for the case of occupied territories, but we have also all the documents that have been developed by the International Committee of the Red Cross that complete this framework.
Marcos, would you have additional comments on this?
Thank you, Cecilia. And I find myself in total alignment with Mara has just articulated. Let me bring a couple reflections on a couple of the things that she's said. So on the point of principle of distinction and proportionality, focusing on distinction for a moment. The point about survival and protection of civilians is certainly a key element of international humanitarian law. I would like to add that similarly is the point about enabling reconstruction and enabling peace building after the conflict has ceased. And so in that regard, water infrastructure or water quality is key, as is obvious, for example, for growing food and agriculture, among many other uses. And so in this latter light of reconstruction and peace building, there's an element that I wish to highlight on the point about distinction. Mara also mentioned about precaution, and I wish to elaborate further on that as well, because one thing that we're seeing in the evolving jurisprudence of human rights bodies in connection with the increasing application of the precautionary principle in cases involving environmental matters is that the contention that there's uncertainty or is insufficient evidence, or there's insufficient evidence of causation in connection with exposure or the onset of disease or other pathologies. That line of argumentation has been increasingly put to rest by the European Court of Human Rights, by the Inter-American Court of Human Rights. And so I sense that the growing understanding of the precautionary principle and its application in human rights cases will lead to its further application as well in international humanitarian law. And the last point I wish to make is the point about prevention. And again, here we see the influence of environmental law, certainly water law, moving into human rights law, and then from there moving into international humanitarian law, influencing practice. And so specifically, the duty not to cause environmental harm, which grew out of the duty not to cause transboundary environmental harm. So this is the international, bilateral, and then multilateral dimension of this obligation, but then also in connection with environmental harm more generally. And so the articulation of states' duties to establish standards, establish plans and measures of protection, to establish monitoring and enforcement. All of this in the understanding that water pollution can affect the effective enjoyment of a range of internationally protected human rights, including, as I mentioned earlier, the right to life, the right to physical integrity, the right to health, the right to a healthy environment, the right to food, the right of self-determination, and several others. And so the prevention of environmental harm, and as Mara mentioned, water takes many forms. And so here we can find that the application of this principle can be multifaceted. But in any event, its application, in my view, is finding its way also to informing the content of international humanitarian law in this field.
Carl, before I come to you, also with your views, and the answer from Marcos was very, very comprehensive, as was the comments from Mara. We have a comment from the audience. If any of you would like to comment on it, customary international humanitarian law prohibits attacking, is only a comment, destroying, removing, or rendering unless objects indispensable to the survival of the civilian population. This prohibition applies in both ISC and NISCs. Would any of you have a comment on this?
I think my comment is just I'm not certain about the customary side, but IHL, particularly Additional Protocols 1 and 2, both prohibit that. Some people who work on the humanitarian side, in the broader context, they read this really as applying to starvation, because often the first phrase is starvation is prohibited. And then for non-international armed conflicts, it says it is therefore prohibited to. And so but it does mention drinking water installations and infrastructure. So I think that there's an ongoing debate, at least within kind of the international humanitarian law community, about the precise scope of that. But the general prohibition, yes, it applies to both international and non-international armed conflicts.
Marcos, do you have any view on this comment?
No.
But if this is not the case, let me.
Oh, it is the case. I just was going to say customary. I'm not certain about, I haven't done the comment, the analysis to say, is this customary law or not? I think it is international humanitarian law. That's all.
Thank you. Yes, Mara.
Yes, I think probably the question can be about the exceptions. So the exceptions to the rule that in the first additional protocol there are some exception to the rule, while these exceptions are not in the second additional protocol. The question can be to what extent the customary international humanitarian law includes or not the exceptions.
Now then, let me go to the topic of policies. How, either if you want to exemplify it precisely with examples, or a more general view, how do we marry, what are the best examples of marrying the policy with the laws? We have all this body of laws, which is necessary and is important. So do we have policies that show is a better application, is the needs to see it from a different perspective from the policy point of view? So how do we marry the policies and the laws? The laws three of you have been discussing so comprehensively. And the policies, not only in terms of water policies, but in terms of overall development, socioeconomic development.
I think we're still trying to figure that out. I think that at least as I've seen it happen over the last 10, 20 years, it's the integration and the alignment of the policies in international humanitarian law have been undertaken from both sides. We see international humanitarian law increasingly thinking about water and the environment and how to address that. And we see a growing effort on the part of the sustainable development community integrating considerations of peace, conflict, and security. And part of the struggle here is that the politics of the UN and the UN structure has implications for the development and interpretation of the law. You have the UN Security Council on the one side, has a lot of power, very non-democratic. And then you have the General Assembly and ECOSOC on the other side, which has all it's one country, one voice. It has responsibility for sustainable development. And there are a lot of countries that don't want to securitize environmental considerations because it takes it out of that more democratic space. And so I think that but we've seen, like with the sustainable development goals, for the first time, the global sustainable development framework explicitly includes considerations of peace. It's not well developed, but it's there. And so I think that we're seeing that integration happening from both sides, from the peace and security side and from the sustainable development side.
Marcos, do you have any comment on this comment from Carl? I'm sorry, your views on the comment from Carl.
Other than I agree with Carl, as I'm not surprised. Perhaps let me add a couple observations. One is that since Rio, at least in 1992, and the advent of sustainable development, there has been a strong push towards integration of environmental considerations, and not just on human rights or humanitarian law, but also on trade, on investment, on finance, and on every element of policy that connects with environmental protection. And so it comes as no surprise that international humanitarian law will begin to integrate, or will feel the pressure to integrate environmental considerations. And water is a key element of the environment in that regard. And so this comes as not a surprise. Now, I also want to echo the point that Carl mentioned, that the UN and also elsewhere within governments, we see still a lot of silos at play. So where human rights are addressed in Geneva, security or some security issues are addressed in Vienna, and politics is addressed in New York, and environment is scattered all around, from Nairobi to Bonn to elsewhere. And so these silos, it is often hard for them to communicate, in part because there is institutional inertia, in part because there's budgets to protect, and so the work plans that are approved under those budgets, some see it as a potential threat for the silos to be talking to one another, and so there's countercurrents and obstacles to integration. It's not only good ideas and concepts, but there's the real world implications of bureaucracy and governance as well at play. And so the challenge there remains in terms of the integration and how the policies will integrate the standards that we've been discussing are emerging in the law in this area.
Mara, would you have additional views?
Yes, maybe not to add to these different silos, from the water perspective. It is really not something particular that we have, because we have from one side the global legal frameworks with the UN Convention on the Law of Non-Navigational Uses of International Water Courses, but we have also the Convention on the Protection and Use of Transboundary Water Courses in International Lakes, that are the global frameworks. So then we have the regional one, like for example in Europe, the European Framework Water Directive, but also in Africa we have several regional framework, for example at the level of the South African Development Community, and then we have basin agreements. And I think that there it would be important to try to include in these agreements a specific provision. For example, like in the case of the UN Water Courses Convention, on the exchange of information, for example, in time of emergencies or armed conflicts. So, for example, in the UN Water Courses Convention, some kind of information should be communicated, even in the case of armed conflict, because this information can save the life of the civilians. And there, it is also interesting to look at the practice of the joint bodies that have been established by these basin agreements, because there are some practices that show that these joint bodies can continue to operate even in the case of armed conflict, because water is is so important, and also has this transboundary nature. When we have international rivers, that it makes that states continue to cooperate in this specific issue. So I think now looking at the future, I think it would be important trying not to include also in the negotiation of new agreements or the practice of the meeting of the parties of the Water Convention, to try to include also the case of conflict and tensions between states. So what to do with these instruments when we are in this situation. Yeah, thank you.
Yes, and this is precisely my next question. So what to do now? There is, I'm sure, enough knowledge, the way the laws have evolved, the policies, the politics as mentioned, the institutional and governance aspects. Where do we go from here? I know it's not one aspect, but multiple ones. Is there any aspect that the international community and also the government should be paying attention to? Is it a combination of them? But due to the fact that we are coming to the end of the Sustainable Development Goals, so we have to plan for a transition. What are our next development goals? How do we include peace? How do we include all these instruments? Carl, if you could please start.
Sure. I thought for a moment you were saying we're coming to the end of sustainable development, and it certainly feels like that right now. But I think a couple of things that I would say. One, as I said in my opening remarks, there are still a lot of violations of international law happening in a number of these conflicts. And I think that it is critically important to hold the responsible parties accountable. Now, we can't always do it in all conflicts for all parties, but to start doing that in specific instances and to build on that. One of the things that we saw with the International Tribunal for the former Republic of Yugoslavia was that the International Tribunal tried a number of the high-profile cases. The countries are still trying cases in their domestic courts. So again, there's this different complementarity between international tribunals and domestic tribunals. And I think that the international precedents and the international efforts to hold some of the highest level people accountable provides an impetus and legitimacy to the domestic tribunals. I think that there are a couple of processes that are underway right now, looking at accountability for wartime damage to water and to other environmental features in Ukraine, with the International Criminal Court, with Ukrainian domestic courts, possibility of other countries exercising universal jurisdiction. There are international assistance that has been provided to Ukraine for this purpose from the US, from the UK, and from the EU. So there's a lot of effort to try to build effective cases. I think that there's some ongoing processes. I'm not as familiar with them around the Israel-Gaza conflict and the targeting of water infrastructure there. The other thing that I would highlight is there's a lot of focus on international criminal law and domestic criminal law. There's also the question of state responsibility and financial compensation. We saw this with the UN Compensation Commission that arose out of the 1990-91 Gulf War, where Iraq invaded Kuwait, and that caused damage not only to the air from the oil wells, but to the water resources. And there was accountability, financial accountability for that. We've seen the International Court of Justice increasingly engage with damage to water resources, including in Nicaragua, Costa Rica versus Nicaragua, but also more broadly around wartime environmental damage, as we saw in the DRC versus Uganda. There is another process that people might not be as familiar with that relates to Ukraine. It's called the Register of Damages. And this is essentially a receptacle at this point where people submit their claims for damage caused by Russia's invasion of Ukraine. The environmental damages, including damage to water resources, are envisioned, but the process for submitting those claims has not yet started. But I did want to put that on the radar.
And now I would like Mara and Marcos also to follow to comment on this, but there is a question from the audience. So if you could please include in your remarks this comment to the as appropriate. I'll give you some minutes to take a look, and then Mara, if you could please express your views.
So for me, before addressing the question, I think that something that I didn't mention before, it is not the issue, for example, of reverberating impacts. So what are the reverberating impacts? It means that we need to consider not only the direct effects coming from a blast, but also over the years, but even the months, that an attack on water or a water-related infrastructure can cause to the health. That was mentioned also by Marcos, the impacts on, for example, epidemics, like cholera, can be related to the attacks on water and water-related infrastructure. So maybe we need to have the development of policy guidelines, to try to establish also the causation, and this is also related to the question. So how you can prove the causation between an attack and, for example, a waterborne disease. Another aspect also of causation can be between an attack against a water-related infrastructure and forced displacement. So to what extent forced displacement is related to an attack such infrastructure. So maybe there, it would be interesting to have some policy guidelines to understand better these linkages. And then, of course, Carl mentioned the issue of accountability and criminal tribunals, but also I think that, for example, other mechanisms like fact-finding, investigation procedure can be very useful, because it can bring clarity about the facts. And many times, in conflicts, in armed conflict, the facts are at the source of conflict between the parties to an armed conflict. And so maybe this kind of mechanism can help to bring some clarity about the facts that then are at the basis for establishing violations of law. So these are my 2 points for the future, and also trying to answer to the question. Thank you.
Thank you. Marcos, please.
Thank you, Cecilia. I'm happy to add a couple of thoughts. I thought I'd put in, first of all, in the chat, a link to the call for input that, as in my role as UN Special Rapporteur on toxics and human rights, I released a couple of weeks ago. in connection with the thematic report that I am preparing and will present to the UN General Assembly in October of this year. I think this is also a good opportunity for the audience to consider sending input and in that way inform what could be recommendations put forward to the international community in this area. So thinking about what the future holds and efforts at accountability, here's an avenue to express views on that. More generally, on a couple of the, putting my hat on as special rapporteur, a couple of the tools that are available for us, it has been called soft accountability, is documentation. And I want to refer to allegation letters I sent along with other special procedures of the Human Rights Council, other special rapporteurs, to the Russian Federation in connection with systematic attacks against the electricity infrastructure of Ukraine. I mentioned this because water is used for cooling the nuclear reactors in various of the nuclear plants in Ukraine, and without access to off-site electricity, to stable, reliable electricity, there is a catastrophic risk of failure. I think we all in this program may remember the Chernobyl and its aftermath, and so speaking about catastrophic nuclear impacts is of course no minor situation, and water plays a fundamental role in that. And so connecting this more directly with accountability, and as Carl was mentioning about various processes underway in Ukraine on these issues. So criminal prosecution, say for example, for destruction of the Kakhovka Dam, destruction investigations on ecocide. I've looked at this matter, as I mentioned, because the Kakhovka Dam's reservoir was supplying water for cooling their nuclear reactors of the Zaporizhzhia nuclear power plant. Now that reservoir has gone downstream, and so there's questions about ecocide. There's investigations going on. There's disinformation campaigns all around by the Russian Federation. I want to be very clear on this as well. The water that's been released is heavily contaminated with hazardous pollutants from decades of dumping of industrial wastes, and so there's a big issue here in the application of Ukraine's criminal code, potential trials in absentia, so guarantees of human rights standards as well do come into play. I think this is also a bridge to pivot to a more broader point about what does potential accountability look like for ecocide at the International Criminal Court. We've seen various proposals put forward for an amendment of the Rome Statute. Some of them rest on a balancing test, and so in that sense, it is hard for any person a priori or ex ante to know clearly what is the prohibited conduct, because it is subject to balancing. This has been argued to run afoul of the principle of legality in international criminal law. So there's a lot to discuss in connection with accountability for ecocide, and also in relation to water in the International Criminal Court. And then going to the question, I think this issue of causation and certainly raises the points about uncertainty. No, and so uncertainties have, as I was mentioning earlier, are beginning to come in human rights law by virtue of the precautionary principle, not just human rights law, but more broadly. In this area, and as Carl also mentioned, we have certain precedents, such as the United Nations Compensation Commission that was set up by the Security Council in connection with the unlawful invasion by Iraq. and damages resulting from that. Several of the cases and the claims that were heard by the Compensation Commission involved issues of uncertainty, and so assessments over the long term. So this places a whole new perspective, I think, on the challenge of accountability, because given the uncertainties and the lack of evidence on causal connections and the need for assessments, and those assessments may take place over not just a year but several years. By the time they come back, the accountability mechanisms that may have been set up to deal with those consequences may already be defunct, and so there's a temporal challenge there in thinking about long-term impacts and accountability.
Yes, and this is not only accountability is very important, but accountability over what time, right? Is it the long term and as it should be, and where does it stop? So in addition to thanking three of you most profusely, let's go to your final remarks before we close. And can we start with Mara, please, and follow with Carl and closing with Marcos?
Yeah, so yeah, my final remark would be maybe to mention that we have a current legal proceeding before the International Court of Justice brought by South Africa against the State of Israel about the possible allegation of the violation of the Convention on the Prevention and Punishment of the Crime of Genocide. We have several orders for provisional measures. So no, this is something also that we need to look at, how it will evolve this case. Now, there are also a number of states that are participating in this proceeding. So no, in international law we have the state responsibility, we have the individual criminal responsibility. So these are different kind of proceedings, and we need really to follow up closely what will happen in the next months and years, and I think that water, and in a sense, I hope that water will be also, the issue of water will be discussed in these proceedings, be international criminal law or state responsibility, since water is so essential for the protection of people.
Thank you very much, Carl.
I want to kind of quickly address two questions that were raised. One regarding impacts of attacks on water infrastructure are increasingly evident, but establishing causation remains challenging amid factors like floods and droughts. How can we measure conflict-related impacts? First of all, often with regards to targeting water infrastructure, the causation is clear. The bigger question is who specifically did it, which individual, and whom should you charge with a crime? I think that tends to be the harder problem, but that often is the question of state responsibility is a way of kind of addressing that. And we have a lot of experience with the scientific assessment of war-related damages and the economic valuation thereof. The other question was related to how do you pursue accountability, including with regards to Israel-Palestine. I would say two things that I would suggest. One, focus on your strongest cases. There's a lot of things that could be claimed, but focus on the strongest cases because there's a lot of inertia in the system. And secondly, sometimes there are accountability mechanisms, and sometimes there are other more transitional justice-related approaches. And we saw with Colombia's special jurisdiction for peace in the Rio Cauca case, the recognition that a river was a victim. Not just that it was harmed, but it was a victim, a legal personhood associated with the dumping of bodies, chemicals from growth of narcotics and illegal mining. And so there are multiple ways of pursuing justice. The final thing that I want to say in this space, one of the biggest challenges for accountability is kind of two questions, actually. One is the dual use exemption. How do you distinguish between civilian and military objects where there is a claim that the civilian object also provided support for military forces? Like the military is getting its water from the same sources as the citizenry. So if you target the military source of water, that's okay. I mean, that's the justification. How do you navigate this question of distinction for dual use exemptions? And secondly, proportionality. Even if there is a dual use, the customary international law does not allow disproportionate attacks. And so how do we measure that? What are the standards for determining if an attack is disproportionate? Thank you.
Thank you very much. And Marcos, please.
Thank you, Cecilia. I'll be very brief. I wish to highlight that with the global recognition of the right to a clean, healthy, and sustainable environment in 2022, not only do we as the international community, the inhabitants of this planet, have a new tool at our disposal to confront the triple planetary crisis of climate change, biodiversity loss, ecosystems loss, and pollution, toxic pollution. But there's also greater awareness of the imperative, the need to do so in order to secure the survival of our species, in order to secure the dignity of so many people that stand to suffer from environmental degradation. And so this greater awareness certainly has implications for our systems of governance. And international humanitarian law cannot be absent from that discussion. And so the extent to which the right to a healthy environment can inform, and by way of interpretation or by way of reforms, the content of international humanitarian law as it relates to water is, I think, going into the future, a key element for us to all think about. Thank you.
To three of you. This has been an extraordinary webinar. I appreciate your time, but also all your insights. Thank you very much again, and for all of those who join us, you can watch this recording again. Thank you to three of you, Mara, Carl, and Marcos. See you again.
Thank you, Cecilia.
Thank you very much.